Hello, my name is Josh Blackman. I'm the president of the Harlan Institute, and welcome to the 2021 Virtual Supreme Court competition. This is the round of eight, the top eight teams. This year, we're arguing the case of New York State Rifle and Pistol Club versus Bruin. We have two excellent teams today. First, from the Burlingame High School in California, we have Elise Spenner and Audrey Young. And second, from the Charles Herbert Flores High School in Maryland, we have Daniela Nat Davies and Amber Ware. Petitioners, begin whenever you're ready.
Mr. Chief Justice, and may it please the Court. My name is Elise Spenner, and my co-counsel is Audrey Young. In September 2014, New York residents Robert Nash and Brandon Koch applied for concealed carry licenses to carry a firearm outside the home for self-defense. Though Nash and Koch met the requirements, officials denied the licenses for lack of a special need or proper cause. The two men and the New York State Rifle and Pistol Association sued Kevin P. Bruin and Justice Richard McNally. The district court dismissed the case, and the Second Circuit affirmed. The Second Circuit reasoned that their decision in Kachowski, a comparable challenge to New York's public carry restrictions, contradicted petitioners' claims. This court granted certiorari.
Can I stop you?
Go ahead.
Just with a clarifying question, when you refer to the claims that you all are bringing, I'm trying to understand the scope of it. Is the argument that the right to keep and bear arms extends everywhere a person happens to be, such that the government has no regulatory authority in any particular place? Is that the argument?
No, Your Honor. The argument is not that the government has no authority outside the home, but that the petitioners retain a fundamental right to keep and bear arms, not just in the home, but at large.
Can I ask one follow-up question, and then I'll turn over to that? So would it be okay, or it's a two-part question, would it be okay for New York, let's say New York City, to prohibit the carrying of guns in Times Square? And if the answer to that is yes, how is that different than this general public carry restriction?
So I am assuming you're referencing the idea of a sensitive place and whether restrictions may be prohibited in certain places and not others. In Times Square, that is a public place that is generally open to access for everyone, so carry could not be restricted. However, if we were to have an area where carry is already restricted, or where access is restricted, like at a school, in a government building, these are long-standing prohibitions on carry, the government could have restrictions.
Well, let me just go back, and this question from Ms. Young. We're talking about history here, right? And you seem to be making an argument that New Yorkers had an unconstitutional law in its books for 100 years. I think there are 7 or 8 other states that have had these laws in their books. We have states going back to the 1800s, the 1700s, the 1300s, right? I mean, let's start from the beginning, the Statute of Northampton, right? How do you square your claim with the Statute of Northampton of the 1300s? I mean, this seems very long-standing restrictions on gun carry.
Your Honor, we argue that the Statute of Northampton actually doesn't contradict our claims, and that's because, as clarified by numerous case laws, the Statute of Northampton really regulates the right to carry, prohibits carrying in a terrifying manner, as clarified by Rex versus Sir John Knight, and also American case law like State versus Huntley and State.
But your friends on the other side cite other evidence, for example, like North Carolina and some other, colonial jurisprudence that adopted the statute in total without regard to the sort of, terrifying language, right? Isn't that common law? It was always a crime to terrify others. I mean, I'm not sure how do we square your argument with the other side reading of Northampton?
I will say that nobody on this side of the Atlantic, as came up in a previous oral argument, has been prosecuted under the Statute of Northampton for carrying simply for self-defense. As to colonial times, carrying was often required by states. It was carried by the founders, and any exceptions to this were generally regulations on a certain time or place, like carrying into Parliament or after curfew. But these are.
Let me ask a question about the type of public carry that you're arguing for. Does it matter that New York prohibits open carry and has this stringent requirement for concealed carry? Or would you be making the exact same arguments if New York allowed open carry?
Ms. Spenner. Ms. Spenner can take this one.
Your Honor, we feel that the real problem in this case is that New York both prohibits open carry and sets severe restrictions on the right to concealed carry. In numerous cases from the 1800s and 1900s, courts upheld prohibitions on concealed carry on the grounds that open carry was allowed. However, we see that New York is distinct from this in that perhaps if it were to allow open carry, it could have similar restrictions on concealed carry. But because open carry isn't available,
what if New York said, okay, we'll allow open carry? Do you guys concede and dismiss your case with prejudice if New York allows open carry?
no, Your Honor, I don't believe so. I believe that there is still an issue with having a subjective requirement.
Right, but let's say they shall issue open carry. Would you be okay with that?
Yes, Your Honor, I believe that a shall issue open carry regime would sufficiently cover the fundamental right to carry outside the home.
Okay, so then is the right to carry then open or concealed? I mean, there's a lot more history on open carry. I get your position open carry, but you're arguing here for concealed carry, right? We're not the New York legislature. What's Ms. Spenner? What actually is the right to carry under history? Is it open or closed?
I think history tells us that the right to carry is, well, as you've said, there's more history behind open, but that one must be available, that we cannot restrict both at once as New York does here. We either must have a shall issue regime for open carry or a objective standard under which petitioners can claim concealed carry.
So when you're thinking about how we should understand, how we should analyze this question, do you think that history answers the question that this licensing scheme is unconstitutional, or should we apply something like intermediate scrutiny or strict scrutiny to analyze the scope of the right?
For Ms. Young.
In Heller, the court advocated a text, history, and tradition approach, but should we use scrutiny, it should be heightened scrutiny. As to
Is it heightened or strict? I don't think you answered this question.
We were advocating strict scrutiny, but should the court apply intermediate scrutiny, it should be narrowly tailored.
Okay, thank you.
Let me go back with one quick question, follow up to Justice Blackman's question a minute ago. I'm not sure which of you is in the better position to answer this, but it's going to what you were saying, Ms. Spenner, about discretion in licensing. If I understand your answer to Justice Blackman, you're okay with shall issue. So in other words, like licensing requirements are okay. It's just that this one is too strict or too much discretion. Like, what's exactly the difference between the New York one and the shall issue ones that you say, I think, are okay?
Yes, Your Honor. In City of Lakewood, the court held that First Amendment jurisprudence tells us that there cannot be absolute discretion. An official cannot have absolute discretion over when a person can express their First Amendment rights. We believe the same thing applies to the Second Amendment. The problem with the Sullivan Law is that it allows officials absolute discretion over granting a license, and it also requires petitioners to establish an atypical need to receive a license. They must demonstrate that they are different from the general public in order to express their rights.
But aren't those two things different? I mean, the second of those shows that it's not absolute discretion. I mean, you have to show you're different from the population as a whole. So that might be too strict, but it's not unbounded discretion, right? Like that's what the licensing official has to answer, right? I'm trying to figure out if the problem is that it's too strict or that it's too much discretion.
We think it's both, and in numerous cases that came before the licensing regime in New York,
Wait, hold on. Let me interrupt you. Are you saying the Constitution requires a shall issue regime, like which I don't think any state had until the 20th century? But is that what the Constitution requires? For Ms. Young.
No, the Constitution does not specifically require a shall issue regime, but it does require it does require that this right be open to the general public, which should be determined by an objective standard.
Then what else, other than shall issue, what other standard are you proposing? Is there something else? I mean, short of shall issue, what would make you guys happy, that you'd be happy with?
Well, New York could have, for example, New York could maintain its current regime, but have an objective requirement.
Isn't that just shall issue? I mean, I think you're saying shall issue is the only way to go.
Your Honor, if I may offer a solution. So perhaps New York could have an objective standard that requires petitioners to demonstrate that they have fulfilled safety courses, that they demonstrate no harm to the public at large, and that they are only using weapons for self-defense. However, the general public should be able to fulfill this. It shouldn't be kept
What about a non-need-based discretionary requirement, like someone showing good moral character? So that's discretionary, so it doesn't solve the problem of discretion, but conceivably everybody could meet that standard. Is that still problematic? And many shall issue states have good moral character requirements. The bar exam taking your law license to show good moral character. Is that okay for New York to require of gun carriers?
Your Honor, we think that would be an appropriate restriction. We understand that New York and other states have longstanding prohibitions on carry by felons or the mentally ill. That would be similar to a restriction that would require a showing of good moral character because the general public would be able to fulfill it without and also demonstrate that they wouldn't cause harm to the public.
So I think you're just about out of time. Thank you very much. Respondents, you have 15 minutes. Please come back on camera whenever you're ready to begin. May begin.
May it please the court. My name is Amber Ware, and I'm here with my co-counsel,
Elena Davis.
and today we are here as the respondents to address the case of New York's penal law versus New York State versus the New York State Rifle Pistol Association versus the Superintendent of New York State Police.
We argue that the Second Amendment does allow the government to prohibit a law-abiding person from carrying handguns outside the home for self-defense because there needs to be probable and reasonable cause for carrying and bearing arms. Today, we will work further to support the law put forth by New York, stating that there must be a special need for self-protection through the means of carrying and bearing arms.
Let me jump in, and this from Ms. Nat Davies. Do you concede that the Second Amendment protects the right to carry outside the home? Do you concede that point?
I could see their point, but
No. Concede. Do you agree that there is a right to carry outside the home?
no.
So New York could just ban carry altogether, no open, no conceal, everything, 100% ban everything.
Wait, no. They have the right to carry outside the home if they have probable and reasonable cause.
So your argument is the Second Amendment protects only a right to carry outside the home with good cause. Is that your position?
Yes.
Okay, all right, you may proceed.
Let me ask one quick follow-up question on that, because I think it really goes to like how we understand this case. Like the text of the Second Amendment, which we start with, of course, says the right to keep and bear arms. I would gather that your opposing counsel is just going to say, look, this is just a case about the right to bear. The earlier cases give us a right to keep in the home, and now we just want a right to bear outside the home. That doesn't say anything about proper cause, right? Isn't this just decided by the fact that the Second Amendment says a right to bear?
I mean, you do have the right to bear arms, but like I said, with probable and reasonable cause, and there comes into the safety of the general public when you bear arms outside of the home.
So that sounds like there's a different interest when you get outside the home. But since the text just has keep and bear next to each other, would you say that New York could have a good cause requirement for having a handgun in the home or keeping it?
It's from Ms. Ware. We can swear.
Yes, New York would have to have a good cause regimen for keeping the gun inside the home, but it is two different scenarios when you're inside the home and outside of the home. They're not arguing that they disagree with the fact that you can't bear arms in the general. They're saying that there should be different stipulations when carrying the arms, when bearing the arms.
Did Heller say you could have a good cause standard for carry outside the home? Did Heller allow that?
Heller did allow you to carry carry guns inside of the home.
But with good cause, or was it?
It was just
scholarship?
in general. And
No. Well, in DC, you have to show you have some specific need for a gun in the home.
yes, you have to, in order to get the license to have your gun, you have to have
Are we talking about in the home or outside the home in DC?
in the home.
I don't think that's right. No, I thought Heller was saying that it's a right, and it doesn't. You don't have to show any need, just apply to the paperwork. Let me change course. Let's talk about history for a bit. The other side says the statute of Northampton. They can see that perhaps it's not the most well-written statutes in old law, but that there's no evidence people are prosecuted for carrying outside the home. How do you respond to that evidence?
For that argument that the law shouldn't be upheld or kept, you have to look at why they actually decided to create the law of Northampton, the statute of Northampton, which basically means that they were worried about being attacked with armed force. And if you give people the power to have guns, what are they going to do with that power?
No, I get that. I get that. And this from Ms. Nat Davies, but is there any evidence people have been prosecuted under the statute of Northampton in 800 years of 700 years for simply carrying peacefully?
I'm not sure that there was any prosecution with the statute of Northampton.
So doesn't that support your friends on the other side's position?
No, I don't think so, because it's still a thing that we should follow, because I'm not quite sure.
Let me ask a question. This could be to either of you. I'm not sure who's up next. How much should we be looking to history to answer these kinds of questions, or is there another way that we should be evaluating the constitutionality of this law? Like, the other side we had some conversation with your opposing counsel about, looking at history or not. What's your preferred way of analyzing this law, the constitutionality of this law? What questions should we ask?
When analyzing the constitutionality of the law, I think that you need to look at history, but you also need to look at today and include both of it in your analysis, because there are specific things that were created in history for a specific reason, but today those specific things may not still apply.
So when I look at today, and this one I can be from Ms. Nat Davies, one of the things that opposing counsel brought up is it seems like really broad discretion that this law gives to licensing authorities to decide who gets to carry a gun in public or not. That seems problematic to me. Don't we usually worry when we have like government officials who get to decide for themselves whether a person gets to speak or vote? Like, how would this be any different than that?
I don't think that this is really different than that, because they still said that you have to have probable cause to have a carrying license outside of the home.
But wouldn't we say it wasn't okay for a state to enact a law that says to get a permit to hold your parade, you have to show good cause to get to register to vote, you have to show good cause for why you want to vote. We wouldn't do that with other constitutional rights, right?
If I could answer for my co-counsel, when you're looking at those specific rights, it's a completely different situation than carrying a gun, because with the power to carry a gun, you also have the power to take someone's life. When you're throwing a parade, because to have people gather. It's not as severe as carrying a gun, because you hold so much power when you're carrying a gun.
So I hear two arguments. One is that the history, you say, supports this restriction, and two, that the modern day consequences support this restriction. Is that the best way to understand your argument, that both history supports it and the consequences of adopting alternative support it? And if so, which of those arguments do you think is stronger, the historical case supporting these laws, or the argument about the consequences of adopting an alternative approach?
I think that the consequences should be stronger, but then you also have to look at history and see what has worked and what didn't work. And if it can apply to modern day, then it should.
Let me ask a follow-up question I guess this could be from Ms. Ware. One thing that's striking about this case is that the law you're defending is in a distinct minority today. Like, there's depending on how you count, it's only 6 or 8 states that have laws like this. And in those other states which have shall issue or permitless carry, it doesn't seem like the sky is totally fallen, which kind of, in other words, like, things kind of seem okay there. So what should we make of the fact that y'all are defending kind of an outlier law here?
Well, every state is different. So comparing each state and the laws that they have is going to be completely different for every state. In New York, specifically, if you look at New York, they have a very large population, and specifically New York City. And there are a lot of places where there may be a higher gun violence necessary. So when you look at these laws and the laws that are in place in these other states, you have to think about, well, what's their population? How much?
What if we said we agree with you, but New York's law is too broad in that it applies to the entire state, right? Could we say New York can't have this same regime for the entire state, including the upstate areas that are not as populated and may not have law enforcement authorities equally spread out throughout a jurisdiction, but maybe it could have this in Manhattan,
heart failure brand prescribed
in the broader New York area?
Sorry about that.
Well, when you look at the idea that, well, maybe they can have it in one area, not another area, it goes down to creating more laws, and it's not a state law anymore. You're going to look at local laws now, and local laws set for that specific area. But when you're creating a state law, they have to think about all the areas together. They can't divide their laws and say, okay, one area can have this, but one area can't have it, because it's still a whole state in general.
Council, let me maybe switch directions a bit. Let's talk about scrutiny. You're arguing intermediate versus strict. If we use strict scrutiny, do you guys lose?
Oh, I don't think that we lose.
Okay, so
Because-
how is your law narrowly tailored, or the least restrictive means to accomplish your state interest? Isn't there some other way you could accomplish this interest?
I don't think there is, because when it comes to gun laws and the power that guns can hold, there needs to be a strict enforcement of how.
But 42 states have a different regime, and they're not, the Wild West, right? They have populous cities like Houston and Dallas and Phoenix. How can you say your means is the most restrictive, narrowly tailored approach?
Well, when you're again, you're looking and you're comparing it to another state, when we shouldn't be focused on different states. We have to be focused on New York and why New York has this law and why New York feels
But
like.
if strict scrutiny applies, that's one way we do strict scrutiny, by looking at how other jurisdictions accomplish the same issue. And New York is as much of an outlier, as Justice Blocher said a few moments ago.
When saying that it's a complete outlier, you have to, that's a pretty extreme definition, that's saying it's an outlier to everything, because
7 out of 50, that seems the vast minority, isn't it?
it could be argued either way, because you have to still think about the different, you have to compare it to the states that do have those laws in place and why they have those laws in place, and are those laws similar to New York and why they need it necessary. First, we're arguing strict scrutiny because we feel that it's a very high compelling government interest to keep the entire population safe.
Is there any evidence about what?
I'm sorry, Justice Charles, go ahead.
I was just going to ask, is there any evidence that New York was considering at the time that it enacted the law, or that it has analyzed since, that shows that this type of restriction is actually helping it reduce gun violence? Would we need that type of evidence? Would it matter if there were no evidence?
I think that it would be important to have that evidence, because it would further conclude that it's constitutional for their right to have the gun laws.
Let me ask a follow-up question for Ms. Nat Davies. What's so wrong with shall issue? Like, how bad would it really be if New York just had to adopt the kind of law that it seems more and more states are moving towards, where there's objective criteria, and if you satisfy the criteria, then you get your license. So you still got to get a license, but it's all set out ahead of time and no discretion. Like, what would be so wrong with that?
I think it's the way that people would use it, especially if you're talking about defense. There's some cases where you wouldn't need a gun for defending yourself in those cases.
Again, I'm sorry, but again, if 40 something states have shall issue, would it be that radical for New York to try it? I mean, we generally don't let constitutional rights vary from state to state. The Miranda warnings are the same in one state versus the other.
Well, if we say that, okay, New York should try shall issue, we have to look into many different factors. We have to make sure that they have a specific low gun violence in the area. We have to compare it to the different states, like you were saying, that have the shall issue requirements. And if they do try it.
If this is a fundamental right, do we really start getting into the sort of balancing test? Didn't Heller reject this sort of balancing approach? You seem to be doing what Justice Breyer wanted to in dissent, and he's gone. Right. So sorry, Joseph. Didn't Heller reject this sort of balancing?
I'm pretty sure Heller said that you could keep guns in your home. Guns were limited.
Right, but Heller also spoke. So do you think Heller said anything, Ms. Nat Davies, did Heller say anything at all about carrying? Was there anything in Heller that suggested the right to carry? Or is Heller only about in the home?
I'm pretty sure there was something said about carrying, but
Well, what did it say?
I don't quite remember.
Okay, that's fine. All right,
Would you
proceed.
say that, so if I stipulate that Heller says the core of the right is self-defense, right, which it does say, And then I add like, well, self-defense can come up wherever a person happens to be. I mean, you know, self-defense isn't always arise in the home. I might be on the subway. I might be in Times Square. Like I might be kind of out in public. Like, shouldn't it be the case that especially people who are living in dangerous neighborhoods or who have to travel through them for work or whatever have a right to also carry their gun in public without having to satisfy some government official first? Like, shouldn't the fundamental right to self-defense extend outside the home? I'd be happy to hear from each of you on that, and then I think we'll probably be out of time.
When looking at the idea of self-defense extending outside of the home, of course, everyone wants to defend themselves by any means necessary, but there is a general population that still also needs to be protected. So like you were saying, you may drive through a bad neighborhood, but where's your final destination? Is your final destination going to be in Times Square where you're surrounded by a lot of people? And what if your gun accidentally goes off and you end up killing someone? What happens then?
Okay, thank you, Council. I think your time is up. I appreciate it. Petitioners, you have 5 minutes for rebuttal. Whenever you're ready, please begin.
May it please the court. Respondents have 2 main arguments. First, that history supports current restrictions, and second, that modern day consequences also warrant this restriction. We argue that this is not the case. To start with history, respondents cite selective history that defends the New York Sullivan Law often had discriminatory roots. For instance, in Dred Scott versus Sanford, Chief Justice Taney infamously warned that giving African Americans the right to bear would endanger the peace and safety of the state.
Whoa! Are we citing Dred Scott favorably? I think we just heard that.
I was citing as an example of how racist intentions sought to limit the right of certain.
But did Taney think the right to bear arms was a fundamental right?
He may have, but he also believed that African Americans weren't citizens and didn't have the right to bear.
Very good. All right, proceed.
Do you think that people who support the law today are racist? Is that what you're suggesting?
Just
No,
Ms.
I
Benner.
don't.
Yeah, go ahead, Ms. Benner.
Okay.
Your Honor, when the Sullivan Law was enacted, it clearly had discriminatory intent. 70% of those prosecuted under the Sullivan Law in its first 3 years had Italian surnames. So we see that from its.
I mean today, when Black men occupy 2% of the population and 37% of gun deaths, I would think that people who are supporting gun laws today may be supporting them to save lives of communities of color. Are you saying that people today who support this law are racist?
No, Your Honor. We're refuting respondents' claim that history defends their position because history and the laws that regulated carry often had discriminatory roots and just that should not be taken as a precedent for the New York's law.
Do the roots still matter today? I guess would be another way for me to ask my question. Even if they're right. I mean, even if you're right, do we really care?
Your Honor, I think we care that the restrictive regimes on the right to carry were often laced with discriminatory intent. Not that they are still today, but
why is it relevant? I think that's my friend's question. Why is this history relevant? I mean, same for there were Jim Crow laws enacted to disarm the freedmen, right? Why is that history relevant in the year 2022?
Is way more powerful even than the flintlock muskets today. How are we supposed to shouldn't we just say this was categorically different what they were doing then from what we do now? How are they even relevantly similar?
Well, I may be citing this wrong, but I believe Caetano versus Massachusetts says that we must also consider the laws or the weapons today to fall under the Second Amendment. And I think no matter what weapon you're using, the right remains the same. We have a fundamental right to keep and bear arms outside the home that can't.
No matter what weapon? What, machine guns? Weapons of mass destruction?
My language wasn't specific enough. Certain weapons that are especially dangerous are long-standing prohibitions to restrict those weapons.
And as to modern day,
let me ask you a question. How many people have to die before you change your position, Ms. Benner? How many people have to die before you change your position?
Your Honor, the New York State Legislature can enact legislation that sets an objective standard if they see a considerable rise in gun deaths. However, that doesn't change the fact that the calculus that
You
we
said, but
can't.
you said, I know you're over time. I'll ask just one more question, but you said shallow issue is the only way to go. It seems that this court would be handcuffing New York to just sit back and say, this is all we can do, no more. You can finish that question.
Your Honor, we don't believe that New York is handcuffed. The legislature can enact objective standards and good standards of good moral character for the people that would wish to carry arms. However, that doesn't mean that they can impinge on a fundamental Second Amendment right.
Okay. All right, thank you,
can't-
Counselor. And I'm sorry, my Zoom cut out for 30 seconds. I'm sorry, I didn't hear questions, but I'll check the recording later. All right. I think the case is submitted. Thank you very much. If the respondents can please, I'm sorry, come back on camera. And let me be the first to congratulate the four of you. That was truly special. What we were doing to you was what we do to third-year law students. Jake and Joseph are professors. I'm a professor. We gave you the full business. We didn't hold back. We didn't treat you like a bunch of high schoolers. We gave you the full treatment. And we give you what's known as the hot bench, which means we don't let you get a damn word in, right? I don't like interrupting people. It's not my nature. But I want to put you through it. And I want to force you at every turn to feel that like you're not on your comfortable space, right? I know you have you have the points you want to go over. You have things that you want to get out, and I'm not going to let you do any of that. And I'm going to keep pushing and pushing you. And if I sense there's even a slight departure from your position, and I get a little bit of a crack, I just pry that crack open. Or if I say something, if you say something that doesn't quite reflect what's in your brief, what's in the case, I'm going to hit you on that. You did well. And a couple of things you did well that are not obvious, but I want to just compliment you on. You're going to get questioned sometimes where you don't know the answer. It's okay to say, I don't know. There's nothing wrong with that. That's the best answer you give. The worst thing to do is make something up, right? Just making stuff up. That is the absolute worst because you get nailed on it real quick. But you say, Your Honor, I'm not sure. What am I going to say? Why don't you know? No, when you say I don't know, it's like, okay, then I'll move on. You're also going to make mistakes, right? You might say something, you might misspeak. I think Ms. Benner said I wasn't using clear language, precise language. Fess up to it and say, Your Honor, I think I misspoke. Or Your Honor, I'm not sure. Or Your Honor, I think I made a mistake. That is completely acceptable. And in fact, I think it's desirable because it shows that you're an honest advocate. You're not here just making stuff up. You're a human being. We're not perfect. We all make mistakes. We all make errors. But you have to fess up when you realize you made a mistake because you're not going to know everything. Even if you're at the Supreme Court, every now and then that lawyers will get stumped, right? They get asked a question where they just like have no good answer. It happens rarely. It doesn't happen often, but it does happen every now and then where justice will just stump them. It's like, Your Honor, I have no idea. Some feedback, and this is just general. Don't use your hands at the podium, right? Because when you talk with your hands, it does get a little distracting. And it's something that I'm from New York. I'm guilty of it. I'm doing it right now as we speak. But when I'm trying to do an argument, my hands are at the podium, fixed and permanent. I think there was a little bit of reading from notes. Try to have your thing memorized. At least in most appellate courts, you have paper in front of you, but you're not really looking at it because you have to kind of look like this. With Zoom, it's actually easier because it's on the screen. Try at least have your opening memorized. Your paper notes are useful for things like like statute citations or citations for cases, maybe, or if there's a specific point in your brief, page 72, and you don't remember the record citation, that might be helpful as well. I think you were also good at transitioning from left to right, from one partner to the next. If you're all in the next round, which I hope you all are, try to be in person if it's possible. I know it's not always possible. You're very accomplished and busy schedules, but it may be helpful for future rounds to do it with the same person, because then you could easily kind of go back and forth. We're in different locations. I'm in Texas. These two are in North Carolina. I think they're in North Carolina now. You are? Okay, I wasn't sure. It helps to be in the same room. But that was really something special that, what do you guys, 16, 17 years old? Yeah.
Oh, that's heartbreaking. You guys are so far ahead of where I was when I was your age. I mean, like,
Seriously.
honestly, like everything Josh just said, I mean, I can't emphasize enough, y'all. Like, I've never done one of these things for Harlan Institute, or, I mean, I've judged high school moot court, so I had an expectation of what 16, 17-year-olds could handle. I came in with all kinds of questions, which I just had to toss out because you guys were so far beyond where I thought you would be. I mean, Jake and I do these things for third-year Duke law students, for advocates who are going, like, literally going to argue before federal appellate courts, and we could just go to those questions. I mean, because you guys were like so ready. It was really, that makes it a lot of fun, frankly, for us. So you guys should feel, like, all of you, extraordinarily proud. Not one of you didn't get a really hard question. Like, you all got really hard questions. Some of them exactly the questions that the advocates got at the Supreme Court at the oral argument in Bruin. And that was a really well-argued case with fantastic lawyers. Paul Clement, who's one of the legends, Barbara Underwood from New York, who was very good, and Brian Fletcher for the United States, who I thought was fantastic. Like, you guys were right up there with them. It was really, really, really impressive. I mean, I won't go through and echo everything Josh said because I agree with it all. But just one other thing I would add is that for me, the best appellate arguments, like this one, where you're before the Supreme Court or some court of appeals, they sort of feel like mutual problem solving exercises where, like, you and the judges are trying to figure something out together, as opposed to, like, you know, you're just fighting with either your co-counsel or with the bench. Like, you want it to be like, yeah, that was a really good question. Let me try to do the best I can figure it out. I either do have an answer or I don't, or here's how I would think about it. That's effective advocacy. And it's like, for a question like this case, which is a really interesting and hard question, it lends itself to that kind of thing. You guys did that great. When we launched, like, big questions out there, like about discretion or about bearing in public or whatever, you guys were like game to just engage. And that was, for us, really, really cool. You were also great on the presentation stuff, which is not easy to do, especially on Zoom and with a partner. And to stop when you kept getting questions from us, I didn't count, but there were dozens of questions, and you all did exactly what you should do, which is, like, the judge's question is the most important thing. It's more important than whatever you're going to say, because they're the ones you have to convince. You guys were terrific, just absolutely terrific on that. So, I mean, kudos, y'all. That was really, really impressive and fun, frankly, for me. Hope it was fun for y'all. It was really fun for me.
Oh, I had a blast.
Let me just agree with all that. You guys did such a tremendous job. Really great on the deferential. One piece of advice is, like Joseph said, because it's a conversation, you can, when there's a question, and even if it's a yes or no question, you want to try to expand if you can. So if we're just asking you a question, the goal is not just to make sure that you're giving your side and then stopping, right? So a trick usually that folks might use is, if it's a yes or no question, you might say yes because, or no but, so you can expand on the rationale for what you're doing. If it's a question, does this old case foreclose your argument? You don't just want to say, no, it doesn't. You want to say why it doesn't. Or if we rule in your favor, is this bad consequence going to follow? No, it's not, because for X, Y, and Z reasons. Because you want to keep the conversation going in your direction and get out as many reasons as you can before the next question. It might take you a whole different direction. You might not be able to get back to that point that you can tell was a real concern for at least one of the judges or justices by the fact that they were asking it. But really, really tremendous job, you all.
Yeah, and we had some really hard questions when you brought up the racist roots of the Sullivan Law. I think Joseph pinned you on that, and then you bring in Dred Scott, and I think you handled that actually very well. Dred Scott's a weird authority because it actually supports your case. It says bearing arms, right? It says it right there in Dred Scott, but who the hell wants to cite Roger Taney? And I know it's Taney, not Taney, but I didn't expect anyone to know that, but that's just, it's Taney.
Spelled Taney, but it's said pronounced Taney.
Yeah, it's like T-A-W, it's if there's a W there, but that, I don't expect you to know that I know that's why I was like 30. But that was really impressive. And we're trying to push you very hard, and you guys didn't flinch. You held your ground so strongly. Anyway, I say this every year, I mean, sincerely, it gives me hope for the future that we have young people like you who can do this, and you'll be leaders. You go to college in a couple of years, you'll be on your moot court team, do mock trial, go take your LSATs, you'll be in law school in a couple more years, and you're going to become attorneys. And there's just the sky's the limit for each one of you. There really is no limitation for doing this when you're 16 or 17. You have no limits. You can achieve great things, and I'm so proud of you.
And if I can say one more, in 6, 7, 8 years, whenever it is you're thinking about law school, please email me so I can try to recruit you to come to Duke, because I would like to have you all in my classes. And that just my a selfish last line for me anyway.
It's always recruiting. He's doing a good job. I like to always give a chance for students to ask some questions. What's on your minds? What do you want to ask us? Free. Ask us anything.
I have a question for petitioners. Do you think there is any option for New York other than a shall issue regime?
That's a good question.
Sorry, was that for us?
Oh, you're asking us how to answer your question. Oh, I thought you were asking the other side. I think, and Joseph, maybe, I don't know if you agree with Doug, I think you have to basically say shall issue. I don't think there's any room beyond that. Joseph, you agree? And Jake?
I mean, so the way I see it is like there's sort of 3 categories. Like there's may issue, shall issue, and then permitless carry. I don't think you want to ask for permitless carry. I don't think you need that to win the case. So I think shall issue is a good place to go. I do think that the line between may issue and shall issue is like a little blurrier than it might seem for some of the reasons that Jake was asking. Like, well, what if there's a good moral character requirement? Does that make it may issue or shall issue? I mean, I think you want to say, and this is what the advocates did at oral argument, is just say, yeah, shall issue is fine. That's all we're asking for here. Objective, get away from discretion. I mean, when I was asking this during y'all's presentation of like, is it the discretion or is it it's too hard to meet question? I think your answer was right. It's both. Both of those are problematic to us. But I think the fact that it's so hard to meet is really the problem, because states could go to shall issue that would be even harder to satisfy than this, and that wouldn't be good for you either. So I think you want to say shall issue is good. That would be mine.
Yeah, the good moral character one that Jake brought, that's a wrinkle. It's hard.
Yeah.
Elise, with your hand up?
I was just curious as to how you'd recommend, like, we talked about like open versus concealed carry, and I feel like that was kind of hard for us to answer because my focus was mostly on, well, New York prohibits both, and that's obviously the big problem. Whereas like there's precedent for like having one and prohibiting the other. So like, what do you guys, from just what you know, like what's the difference between those two, and like how does that factor in?
I think if you're either one, then you should be okay. I think you answered it right. Eventually, it was just to say like, yeah, New York's got to choose one or the other. There has to be a way to carry a gun in public, and they can choose between those two, but it's got to be one or the other. I'm sorry, Jake, you're about to answer it.
No, I was going to say the exact same thing, which is what they said, which you want to make, from your side, you want to make this a case about whether or not you get to carry a gun in public at all, not whether or not there's history supporting the right to concealed carry, because that is much harder. So
that's not good for you.
I tried pushing you on that, and you didn't take the bait. Daniela or Amber, you have any questions for us?
Just the best way to incorporate the Heller case into our argument, because we had a lot of questions about that.
Yeah,
I think for you all,
go ahead, Joseph.
Sorry. I think what we want to say is that basically all Heller says, because all Dick Heller asked for is that there's a right to have a handgun in your home for self-defense. Like that's all Heller resolved. The next question you're going to get is the kind of thing I was suggesting, which is, yeah, but Heller says he gets to have that because self-defense is the core of the right, and doesn't that logic extend outside the home? But I think you want to say like, that was in some respects a narrow case. DC had a really draconian law, which basically prohibited anybody from having a handgun in their home, even for self-defense. And so that's all the court had to decide, and therefore that's all the court did decide. And then the next question is going to be, yeah, but doesn't the logic suggest otherwise?
And also sensitive places, right? If there are sensitive places, that suggest some places are not sensitive. And that was a very important part of Heller that's been cited millions of times in the last decade. Joseph's being modest. He wrote one of the leading articles on Heller, was it 2010 or so, in NYU Law Review. So his writing on this has affected the jurisprudence in ways that are hard to quantify. So he's being modest as usual, but his advice is a good one to follow.
Josh, we're in the same category here. We've both been writing on this issue for a very long time. We're
like
getting
forever.
old. It's been 10 years we've been writing on this.
I was an RA. I was a 3L when Heller was decided, or a rising 3L. And I was actually a research assistant for Nelson Lund in 2008 for his Heller brief.
That's so funny.
That's good. Where were you when you wrote Constitutional Cost? Had you already started teaching?
I just graduated. I was clerking.
Wow, crazy. I'm sorry, that was just us cross talking. I'm sorry. Do you guys have more questions?
Daniela, anything you want to ask us?
Not really.
You guys going to law school, all 4 of you? maybe.
Yeah. I have
Come-
another question.
Please.
I'm not sure if it's like a question we can ask for the because it's a competition. But if you guys were arguing this, like what side would you want to be on?
Before, it's a
Well-
really, I'm going to duck it by saying this. If I were arguing it before the actual Supreme Court as it's currently constituted, I would much rather be the petitioners than y'all. I
Yeah,
think they have.
you guys did a brief
Given the
in support
current
of neither
line
party,
of
right?
support-
I think your brief was
What's
for-
that?
Was your brief in support of neither party?
Yeah, I filed a brief in this case, but not supporting either one, because I'm more interested in the methodology than I am in the outcome of this case or whether New York's law gets upheld. But yeah, I think the petitioners have a better draw given the current makeup of the court.
Yeah, no, I think that's right. I mean, when you guys become real lawyers, you're gonna have to pick, what kind of clients you want to represent, and it's your choice, right? You can choose to represent on one side or the other. You can file, so Jacob and Joseph filed, what's called friend of the court briefs, where they basically tell the court information. They're not parties, but they sort of give information to the court. That's something that's very useful. I think on the lesson I linked to a bunch of the amicus briefs, friend of the court briefs. Maybe I linked to yours. I can't remember. If I didn't, I should
No,
have.
ours is two in the weeds, and it's just mine, I should say. It's me.
Yeah, I'm not
Daryl,
on the. I'm not on the.
Oh, I'm sorry. I thought you guys did it together. Okay. All right. My mistake. Actually, Daryl judged with us yesterday, so I got all the dookies in.
Oh, nice. Excellent. Yeah, you got the
All right.
whole crew.
All right. Anything else from the students? We will have the grades. I'm sorry. Go ahead. I'm sorry to interrupt you.
I've got one more question.
Please.
It seems like different ways to approach this, right? Like with interest balancing, which like the court kind of rejected, and then text history and tradition, and then scrutiny. Personally, what do you guys think should be applied?
So this was my brief. I'm not a big fan of text history and tradition as a sole approach. I think the history matters a great deal, but it should matter as scrutiny, tiers of scrutiny usually work out. I mean, this is what Josh and I have both been writing on for 10 years. I think from your position, what you want to do, like given your assigned roles, I think it's a good idea to start with text history and tradition. And if you get pushed on that, you can fall back and say, we win under tiers of scrutiny anyway. And the difference between tiers of scrutiny and interest balancing, it's almost academic. I wouldn't focus on it too much. I would look at it as two options. There's basically text history and tradition, tiers of scrutiny, and you want to, I think, start with the history and then go to the scrutiny from petitioner's position.
No, I will say that if for the other side too, you don't want to concede that interest balancing is the same as tiers of scrutiny, because Heller said interest balancing is off the table. So you want to be able to.
Agreed.
All right, we have another round coming in a few minutes. They're already in the waiting room, so I'll have to bid adieu. We'll be posting the scores either by tonight or by tomorrow, so we'll get the score soon, and we'll let you know which rounds, which teams are advancing next round. But I want to say congratulations. You have my contact information. If you have any questions, please reach out to me. I'm happy to answer any questions you have. And I want to say congratulations again. Thank you all so much. So students, please sign off when we talk to the
Great
judge.
job.
Here. We'll confer. And reach out to me if you have any questions. Happy to chat.
Thank you.
Thank you so much.
Bye.
Bye.
How do you put the cord in the